Well, hello and welcome to our June 2022 outline. We'll just give everyone a couple of minutes to get logged in and joined, and then we'll begin. So we've still got quite a few people joining, so we'll just give people a little bit longer to get logged in, and then we'll get started. Okay, well, hello, welcome to the June 2022 edition of Outline, DLA's Planning Law Update series. Today we're going to be talking about the Levelling-Up and Regeneration Bill, or LURB, as Claire has just told me it's called by its friends. Just before we get into that, I will just introduce my colleagues. I'm joined today by Claire Stoneman, making her debut on Outline. Claire is a legal director in the planning team here at DLA, so welcome, Claire. Also joined today by regular Outline contributors, Pieter Claussen, Senior Associate, and Tobias Paul, who is an associate. So hi to the three of you and welcome. Now we're talking today about the Levelling Up and Regeneration Bill. There is a lot in the bill. We are only going to talk today about the interesting bits that relate to planning. We're not going to try and cover it all. We couldn't possibly do that in an hour, and frankly, a lot of it wouldn't necessarily be terribly interesting to many of you. But the bill, as ever, when planning is being reformed, the bill has had a complicated history even before it became a bill. We started, if you cast your minds back to August 2020, we had the Planning for the Future white paper published by what was then still, I think, MHCLG. And some quite radical reforms there that were meant to transpire into a planning bill in due course. There was then the inevitable reshuffle, and as is always the case with a reshuffle, we had a new minister in charge of planning, and with the entrance of Michael Gove, those reforms seemed to get to a great extent put on the back burner, for want of a better phrase. And so what we now have is a very different set of proposed reforms to those which were outlined, the zoning type approach that you may recall from the white paper. But there's quite a lot to it, as I say. We are going to try and cover the most interesting and most relevant bits in the next 55 minutes. We are going to keep to the hour, so warning to the panelists, I am going to keep you moving because there's a lot to get through, and we want to make sure everybody's away on time as always. So without further ado, let's crack on. I want to, perhaps Claire, if I can come to you first. One of the changes is to the development plan and the plan making process that is proposed in the bill. I think in terms of the changes that are coming through, one of the changes is to change what constitutes the development plan for the purposes of planning legislation. Now, the explanatory notes that accompany the bill, they indicate that these are procedural changes, but I just wonder, is that the case?
Yeah, so the explanatory notes are badging the changes as being procedural in nature in order to create consistency and to update existing definitions. But actually, within the list of what comprises the development plan, we do have a new addition, which is the supplementary plan. And supplementary plans are effectively going to replace supplementary plan documents, what we now know as SPDs, which do not currently form part of the development plan and have always had a status which has been a little bit uncertain. The policy paper, which was published alongside the bill, tells us that the intention is for supplementary plans to be able to be prepared quickly. And it also sets out what they may include. So they can include policies in relation to the amount, type, location of development at a specific site. And the example given is that they could be prepared in response to a new regeneration opportunity which comes to light. They can also specify objectives that relate to particular characteristics or circumstances of a site, detail infrastructure requirements or requirements for affordable housing, and also can make requirements with respect to design, either on a particular site or throughout an area. One difference is that these supplementary plans will have to go through a written examination process, which isn't the case for SPDs, but does make sense given the status that they're going to have.
So is there going to be, you said there that they could cover, for example, a regeneration site that comes forward. So with SPDs, one of the things that we'd say at the moment is that they need to be in accordance with the local plan. Is there more flexibility then actually to sort of bring forward new policy under these new documents than there is? Yes,
I suppose the supplementary plan can be put in place quickly once you already have a local plan in place, and they will supplement what's already in your local plan, but carry the same weight.
Yeah, and with an examination process, because one of the challenges with SPDs, isn't it, is that they can be brought forward with little or no consultation.
Yeah, exactly.
But that there is going to be some form of consultation and scrutiny that goes into that process.
Yeah, that's right.
Yeah. And it's probably worth on that. One thing that's going to be a recurring theme during the course of the next hour is the fact that a lot of the detail is not set out in the bill, is it? A lot of it is in regulation. So we've sort of got the high level, big picture stuff today, but actually the nuts and bolts will emerge over time as the legislation moves through Parliament, and ultimately the various regulations are brought in after that. But I just say that in passing as a note. But coming back to development plans, in terms of the plan making process, Claire, there's a whole new schedule being introduced. I'm not suggesting we go through that in line by line. That would take more than the hour to start with. But can you perhaps just flag up what are the most significant changes for our audience, please, in terms of how plan making is going to happen?
Yeah, so I think it's, before we talk about the changes, it's useful to look at the background as to why they've come about. So currently we only have 39% of local authorities which have an update local plan in place. And so the intention is to try and make the planning process more streamlined so that plans are faster to produce, and to increase the number of local authorities who have plans in place. One of the changes is that local authorities are no longer going to be allowed to have a suite of development plan documents, and instead are going to be required to prepare a single local plan, which is to set out the amount, the type, the location, and timetable for development in their area. And alongside this, they are also going to be required to have a policies map. As you said, regulations will be coming forward in due course, and they will be setting out timetables for plan production. But we are told that the expectation is that plans are going to be produced within 30 months end to end. And within this 30-month period, they are going to be subject to 2 rounds of community engagement before being submitted for examination. Now, I think 30 months does seem to be a short time frame. However, when you consider the changes to what the local plan now is to include, perhaps it'll be more likely that a plan can be secured in this time. So local plans will have to have regard to and have to be consistent with national development management policies. Now, I know Pieter is going to discuss these in more detail in his section, but the plans will now not be allowed to repeat any of those policies. So instead, they're intended to be shorter, more condensed, and instead only focus on spatial matters of what development should go where. Gateway checks are also going to be introduced during the plan making process, whereby there's going to be a person appointed by the Secretary of State who will give observations and advice on a draft plan. And the plan is for this to identify and correct any problems before plans get to examination. There's also going to be a lot of power for the Secretary of State to intervene in the plan making process. And we've got the introduction of local plan commissioners who can be deployed to support or even to take over plan making if local plan authorities fail to meet their statutory duties. I think one thing that we don't have any information on currently, which will be interesting to see how it develops, is the transitional provisions. So I think any local authorities who are currently going through the plan making process don't really have any information, or don't have any information at all as to where they currently stand with their draft plan and how they should continue with that until the new process is introduced. And I also want to touch briefly on neighbourhood planning. So there's clarification in the bill as to what can be included within neighbourhood plans. And as with local plans, there's going to be a requirement for neighbourhood plans to be in general conformity with national development management policies. And there's going to be a new requirement, which I think is a helpful clarification, that the making of a neighbourhood plan must not have the effect of hampering housing supply. So the neighbourhood plan must not result in the local plan proposing less housing than it would if the neighbourhood plan were not made. And finally, we have the introduction of what's to be known as neighbourhood priority statements, which are said to be in response to the uneven take-up of neighbourhood plans across the country, particularly in urban and deprived areas. And they're intended to be a simpler way for communities to set out priorities and preferences. However, they don't look to be a document that must be taken into account in decision making, albeit they must be considered during the local plan making process. So I think there's a question there as to the extent to which these statements will actually fulfill the purpose that the government set out.
I promised myself in preparing for this session that I wasn't going to be too cynical today, but I can't. We're only 10 minutes in, and there's just a couple of things you said there. One, that we're going to speed up plan making. You just think yes, because we haven't heard that before, have we? It was that was at the heart of the 2004 Act and the changes made there, and now we're sort of unpicking a lot of those. It just feels to me that there's been a power for the Secretary of State to intervene for a very long time. There's always been a reluctance to do that, and when he has intervened, London, for example, that's hardly sped up the adoption of the London plan. In fact, it's delayed it massively. So I wonder, without being too cynical, I wonder whether these reforms can actually speed up plan making, or whether actually, if you're going to speed up plan making, what you need is more resources in local planning authorities to be able to bring it forward. And the losing of the development management policies from the plan, well, the bit in my experience that tends to take the time is arguing about the housing numbers, arguing about the allocations, where they're going. That's the bit which is still going to be in those plans and is still going to be the bit that people will have very strong views on, I'd have thought. And I'll avoid, I won't say what's the point of a neighbourhood plan if it's not there to stop housing, because that would be far too cynical. So I shall definitely not say it. Whoops, I just did. We've had a question come in just asking whether there'll still be separate minerals and waste local plans. I think we can answer that in a word, can't we? Yes, there will be.
Yes. Yep.
Yeah. Great. And then just finally on development plans, we're losing the duty to cooperate, which was brought in under the Localism Act back in 2011, as I recall. That was intended to sort of replace the loss of regional spatial planning. I think pretty much everyone agrees it hasn't worked terribly well. But what's the new approach to trying to ensure that we have that cross-boundary strategic level to planning?
Yes, there's a few different things which are being introduced. The duty to cooperate as a statutory duty is going to be repealed, and we've been told, a more flexible alignment test, which is going to be set out in policy. We've got no detail as to what that test is going to look like, so it's hard to say how it's going to work and if it's going to be more effective. But alongside that, there's going to be a new requirement on public bodies to do everything reasonably required of them to assist in the plan making process if they're asked to do so. And then looking at things from a spatial and regional perspective, there's going to be two powers for local authorities outside of Greater London and combined authorities to work together to create a spatial development strategy to focus on matters of a strategic nature outside of those matters in the local plan or national policy. And then also the power for local authorities to come together to create joint local plans. But both of these powers are entirely voluntary. And I think given what you've already said about resourcing issues, it's going to be interesting to see whether any authorities actually take up any of these joint planning options.
Yeah. Okay, thank you, Claire. And just you mentioned earlier the sort of change to what a local plan is going to contain. So that probably moves us on to what I think is one of the biggest changes that the bill is proposing, which is changes to Section 38(6) of the Planning and Compulsory Purchase Act 2004, as it now is, and that's the statutory basis that underpins all of planning decision making, and effectively requires that any determinations are made in accordance with the development plan, and unless there are material considerations that justify a contrary decision. Now that's a test that's been with us since long before 2004. It was first introduced into the 1990 Act in what was then Section 54A of the 1990 Act in 1991, and it's underpinned the plan-led system that we often talk about having in England and indeed in the rest of the UK as well. Now the bill is proposing some fundamental changes, and they're partly, obviously, they're linked. The development plan itself, as you've just explained, Claire, is changing. So what constitutes development plan is going to change. But there are two big changes to this test, and it's going to upset everybody who's ever been my trainee, because you're all smiling, because as you all know, anyone who's ever been my trainee is within weeks of being in their planning seat can recite Section 38(6) word for word, or if not, they owe me a drink in the pub, because it's so fundamental to how we approach planning. And there are people who've gone on not to be planning lawyers, have gone on to be banking lawyers and all sorts, who can still 20 years later quote Section 38(6) because I've instilled it in them. And now they're all going to have to learn something different. So Peter, turning to you, two changes. Let's start first of all, this new concept of the NDMP. What is it, and what role is it going to play in the planning test?
Yeah, thanks, Trevor. So the bill replaces the Section 38(6) formulation which you just described, and instead provides that determinations must be made in accordance with the development plan, as well as this new concept, which are national development management policies. And that's the first part of the test. And I suppose the brief answer to the question of what an NDMP is that we actually don't know at this moment in time. It's the first draft of the bill, and as you said earlier, Trevor, the devil's going to be in the detail of what happens later down the line. But I suppose we can cover off some things that we do know, and we have been given a definition for a national development management policy, and that comes in clause 84 of the bill, and essentially provides that it's a policy which the Secretary of State directs should be a national development management policy. Now, to my mind, there's an immediate question mark over that in terms of how the Secretary of State will make that direction. And I suppose more importantly, how much consultation will need to be undertaken before a direction is made. And again, as is the theme throughout this talk, I suppose it's that the devil is going to come in the detail later down the line as the bill passes through. As I mentioned earlier, the NDMP is a concept which is being moved to the front end of the Section 38(6) test, and so is to be considered alongside the development plan when making any determination under the Planning Acts. Now, what's really interesting there, though, is that if there's a conflict between the development plan and an NDMP, then the NDMP will take precedence. So we are sort of downgrading the development plan already. But I suppose what we don't know is what the NDMP is going to be. I mean, is it going to be the NPPF, or is it going to be the NPPF under a different guise, or is it going to be a different beast entirely? And actually, I think the answer to that question is going to be one of the most important things which comes out of the bill, and could either be a real positive or hindrance to developers. Sorry, go on, Trevor.
Sorry, it's a really good point, because I think you try to wrestle with is this going to be a pro-development change, or is it going to be an anti-development change? And I think a lot of it, you're quite right, to my mind, depends on what the NDMP is. If the NDMP is the MPPF, well, actually, that might be quite pro-development, because quite often the MPPF is more pro-development, assuming it doesn't get amended, which there's obviously discussion of that changing as well. But in its current form, it's probably more pro-development than the average plan. But on the other hand, if it's not, then it may become quite difficult. But we've had a question, which I think links directly to this issue, which is what's the situation if where we have a local plan with policies that are more stringent than the national policy or national guidance. And the example that the question is given is in relation to flood risk. Is it possible to maintain that more stringent requirement in a local plan? I suppose the answer is it depends on whether that more stringent or the less stringent policy is in the NDMP or not, does it?
Yeah, absolutely, because the NDMP will take precedence if it's in the NDMP, and so if not, then I suppose you would still have regard to the local development plan, and then we'll move on to material considerations in a while. But I suppose it would then come down to whether material considerations strongly indicate otherwise if it's not. Yeah. In an NDMP.
So, and I think there's a sort of link, isn't there, back, Claire, to what you were saying in terms of the development plan and the local plan bit of the development plan effectively losing the policies that are contained in the NDMP. They won't have that. So that, again, it comes back to this point. You won't be able to have a more stringent requirement in a local plan than is in the NDMP. But if it's in any other form of government guidance or government policy that isn't designated as NDMP, you've still got that ability to bring it forward as part of the development plan, and then decide the weight to attach to the government policy as a material consideration. Are we all in agreement with that? An answer to the question.
Yeah, absolutely. I think just going back to the MPPF, what's interesting to me is that it obviously has been a material consideration in the determination of planning applications, which has essentially been used as a tool to sort of hit LPAs with when they've got out of date plans for the last 10 years or so. So actually, if we're moving the MPPF to the front end of the test, I suppose the question then becomes, well, what is a material consideration? Is it sort of something? Does it mean that something actually sort of has to substantively change or not? I don't think we know the answer at this stage, but it sort of begs the question, doesn't it?
It does, and that sort of ties in with my next question for you, I suppose, because the other aspect of the change to section 38.6 is to where material considerations fit in that development plan determined in accordance with the plan unless material considerations indicate otherwise. Can you just talk us through what the change is to that sort of second half of the planning balance test?
Yeah, of course. So as I touched on earlier, the proposed reformulation under the bill is that determinations will be made in accordance with development plan and NDMPs, but the second part now is that unless material considerations strongly indicate otherwise. So I mentioned a minute ago that we don't really know what a material consideration at this stage, but certainly on my first reading of the word strongly, it struck me as being a potential concern for developers and development. For example, what if you have a scheme which is mostly compliant with the plan, but there's a very small aspect of the development which is contrary to the plan? Is it now more difficult for developers to overcome and secure a permission in those circumstances when they're having to show that instead of just material considerations indicating otherwise, they now have to strongly indicate otherwise? So it begs the question whether there is a higher threshold which needs to be overcome. And I suppose for me, we obviously don't know the answer to any of this, going back to what we said earlier. But yeah, it's an interesting one.
The two issues are very definitely linked, aren't they? Because I think clearly having a requirement that you've got to strongly outweigh any conflict with the plan, that must be a higher test. But the biggest material consideration in almost every planning application I can think of in recent times is the NPPF. So if the NPPF becomes the NDMP and therefore is the development plan, then actually it feels like it's perhaps less concerning.
Yeah.
But if a lot of the pro-development stuff in the NPPF were to disappear, or if it just never gets designated as part of the NDMP, so it remains on the material consideration side, then actually the things like the tilted balance, for example, that suddenly the balance is not tilted quite so far, or quite so easily, perhaps in favor of an approval. And I think that for me is quite a challenge. But the other thing is this idea of strongly outweighing. Where does that sit with planning judgment, Peter? Is that ultimately whether something outweighs a little bit or strongly outweighs? Is that not ultimately a matter of planning judgment?
I think it has to be, doesn't it? And it will come down to the decision maker in every circumstance deciding whether something strongly sort of is a material consideration, or whether they just go back to the previous test. I think it is still a matter of planning judgment. And actually, we might end up litigating as to what the word strongly means, but I suppose the courts aren't going to be interested if it is just a decision maker exercising their planning judgment.
I think that has to be right. And at that point, if you're minded to approve as a planning inspector on an appeal, for example, if you're minded to approve, you just need to use the word strongly in front of the word outweigh, and you're away. And actually, as long as you're not Wednesbury unreasonable, irrational in that, you can actually come to the same decision. So a lot of this, I think, is going to depend on the attitude of the decision maker, and how the individual decision maker approaches the use of the word strongly.
I think on that point, Trevor, there's potentially a parallel to the very special circumstances test in the NPPF for greenbelt development, because there's obviously over the past few years been quite a fairly involved line of case law, and ultimately where that ostensibly quite high threshold is reached is that very special circumstances don't have to be unusual in themselves. It's simply a case of how much weight does the decision maker give to them in that balancing exercise. And so it may well be that the strongly indicate otherwise for material considerations, a similar approach is taken on how much flexibility the decision maker has.
I agree, Tobias, and actually you've been remarkably quiet up to now, uncharacteristically quiet, I might say. So I'm going to move us on because otherwise time is against us. But if I can perhaps just come to you, Tobias, and we can probably deal with this bit quite quickly, but the statutory duties that currently apply to listed buildings and conservation areas, the bill is proposing extending those to a wider range of heritage assets, isn't it?
That's right. And somewhat weirdly, while so far the discussion has focused on sort of forgetting everything you thought you knew about the planning system, actually on the heritage front, what the bill would achieve is actually to pretty much consolidate what we're already doing in practice. So at the moment, for listed buildings and conservation areas, there's a specific duty for the planning authority to pay special regard to the desirability of, in effect, preserving their heritage significance when they exercise functions under the Planning Acts. What the bill would do, it's in Clause 92, but it would add a new section to the main Town and Country Planning Act 1990, which would in effect apply an equivalent duty for scheduled monuments, protected historic wreck sites, registered parks and gardens, registered battlefields, and World Heritage Sites. So in effect, it's all the other categories of designated heritage assets. And it would apply the same legal duty by and large, as already exists for conservation areas and listed buildings. What's interesting, I think, is that regardless of the legal niceties, the NPPF chapter on the historic environment already says you should be considering these things anyway and considering them in the same way. And so on a practical level, this isn't sort of a particular major change, but it is interesting that the government has nevertheless thought it is appropriate to place it on a firm legal footing, which emphasizes the value that they place on preserving the historic environment.
Yeah, I think that the Mordew case said, didn't it, broadly, that if you've properly applied the policies in the NPPF, then you've met the statutory tests in almost all cases. So you're right on a practical level. As long as we all keep applying the NPPF policies in the right way to these various different types of designated asset, then nothing's going to change. But there is that legal duty, which immediately opens up a greater risk of potential challenges if you get it wrong, doesn't it? It starts being about legal duty rather than decision-making discretion and application of policy. So it feels like it's a one that's going to be important to get right, but actually you get it right by doing what you've always done, just doing it properly.
Or what you should have done.
Or what you should have done, yeah.
And I think here, this is actually somewhere where sort of developers who are proposing an application can actually assist the planning authority as well, because most validation checklists require you to submit a heritage assessment if there will be potential heritage impacts. And so that is one avenue where you could actually just set out what is the correct policy approach, and then that helps to guide the planning authority through its decision in a way that complies with the legal duties.
Thank you. And another topic I want to cover, but very briefly, if I may, and Peter, perhaps I can call on you too. There's a proposed change to the way that we vary planning permissions, isn't there? We've currently got Section 73, we've got Section 96A. We're going to have a third option. Tell us a little bit more about why we need a third option.
Yeah, so we're going to have a new Section 73B, and I think if we just rewinded it a bit, you'll recall that the Finney case was embroiled in whether Section 73 could be used to amend the description of development, and the Court of Appeal ultimately found that a condition that altered the nature of what's permitted was unlawful, and that a Section 73 essentially couldn't be used to amend that description of development. I think whilst that was a frustration across the profession, it wasn't perhaps surprising when one considers that an application under Section 73 is actually an application to remove or amend a condition attached to a planning permission. But I suppose Section 73B, in response to this, according to the explanatory notes accompanying the draft bill, is an attempt to, and I quote, overcome the confusing, burdensome and overly restrictive process, which it then goes on to say that it's been compounded by recent court decisions. So essentially what Section 73B is, it introduces a new route to vary an existing permission and permits non-substantial changes to that permission, and in including the description of development, which it's specific on it, again in the explanatory notes. So an application under Section 73B will only be granted permission where the local authority is satisfied that its effect will not be substantially different from that of the existing permission. And I think that tallies quite nicely with the line of cases that we've got to date that sort of says you can't go beyond the scope of what was originally permitted under the original planning permission. I suppose just the other thing to add that is as with Section 73, you won't be able to extend the life of a planning permission by changing the date for commencing or submitting reserved matters.
And are you still going to end up like with Section 73? One of the things that people often overlook is that we call Section 73 a variation application, but it's not. You come out of a Section 73 with a new planning permission, so you end up with two with different conditions. Is that going to be the same with Section 73? Do you get a new permission, or is it going to actually vary the one that you've got in your hand to start with? No,
it is, and what it's actually going to do is bring everything. It's going to bring everything together. So what you can't do with this new Section 73B is make an application against a previous Section 73 permission. So you've got to make the application against the original planning permission, but then whilst you're doing that, draw the local authority's attention to any other Section 73s or 96As that have been granted pursuant to that permission. And then what you'll ultimately end up with is I suppose, a consolidated permission sort of that brings everything together.
Right. Okay, well, that's certainly, it's certainly something that needs to happen, the challenge of trying to get things amended where you partly use 96A, partly use Section 73. That feels like it may be a positive.
I think so. I think the other thing that it's probably going to have to widen the scope, though, because as I said earlier, when we're looking at Section 73, you're looking at conditions essentially. But if you're looking at Section 73B and sort of the ability to change other things other than a condition, then I think naturally what a decision maker is allowed to take into account surely has to widen in its scope.
Yeah, I think that has to be right, doesn't it? If you're changing
the
development that's permitted, then the principle of development, at least as far as the change is concerned, must be back on the table in a way that it isn't with Section 73.
I think so.
Yeah, great, thank you. Now I want to come on to one of the other big topics that's in there, so which has a whole part of the bill to itself. So far, we've just been talking about the part that deals with changes to the planning system, but we then have a new part for the infrastructure levy, not to be confused with the community infrastructure levy. Apparently, it's a wholly different beast. Claire, perhaps you can start us off. What is infrastructure levy?
Yeah, so as people seem to be calling the bill LERB, I'm hearing a lot of people calling the infrastructure levy IL, which isn't the nicest thing to roll off the tongue. But it's one of the survivors from the white paper, which has actually made it into the bill. At the moment, what we have in the bill is a similar structure to the primary legislation for SIL. But again, as with SIL, a lot of the detail is going to come forward through regulations. And we are being told that the regulations will follow consultation on the proposed changes. So in order to understand what's really envisaged with this, most of the detail that we have is in the policy paper, which is saying that the reason for the changes and the introduction of the new levy is to make sure that more of the money which is accrued by landowners and developers is actually going to go towards funding local infrastructure that's needed. If I just highlight some of the main points coming out of what we know, first of all, it is going to be mandatory for charging authorities to charge IL, which is a significant change from the SIL regime. So with SIL, a charging authority has the discretion to decide whether or not it wants to charge the levy by introducing a charging schedule. So now authorities are going to have to charge IL, and the bill gives the Secretary of State the power to set a deadline for an authority to introduce it, and also to intervene to get a charging schedule in place where a charging authority isn't doing so. Like SIL, the charging schedule is going to be set locally, and there's also going to be a minimum threshold under which the levy won't be charged. And in setting the rates of the levy, the charging authorities are to have regard to economic viability of development. Authorities are also going to be required to prepare an infrastructure delivery strategy, and this is what is going to set out the strategic plans for the application of the levy in that area. The strategies will require examination, but we're waiting to see in the regulations the detail as to how this will be carried out. And the policy paper suggests that those regulations will also enable charging authorities to get infrastructure providers involved in helping to prepare the strategy. One headline change, I suppose, of the new levy is that the definition of infrastructure as we know it for the purposes of SIL has been widened out to now cover affordable housing. And the government's intention is that the levy is going to secure at least as much affordable housing as we currently see delivered via developer contributions. And in addition to that, there's also going to be a right to require, which will remove the negotiation process in determining levels of on-site affordable housing to be provided. Again, another big change from SIL is that the levy is going to be charged on the value of the property when it's sold, and the rates are going to be set as a percentage of the gross development value of the property rather than the floor space as we have with SIL. We don't have any information currently as to when gross development value is going to be calculated, and it's also not clear what is going to happen in circumstances in which there is no sale at the end of a development. And another change which is going to increase the scope of the levy is that it's going to apply to change of use of an existing building, which is not currently the case for SIL as you go through netting off floor space.
And you've made the point that the devil here really will be in the detail of the regulations.
As we keep saying, yeah.
As we keep saying, but here I think it's particularly relevant, and certainly when I think back to SIL, the devil is still in the detail because they haven't quite got the SIL regs to work, to my mind, which is why they have to keep amending them. So a lot of this we just don't know, and we're a long way, even if infrastructure levy survives the parliamentary process and is ultimately enacted, we're still probably quite some way from seeing the detail of how this is going to work. So I think we all need to keep that in mind. It's quite a way off. But just sort of looking at what we do know in a little bit more detail. So this is intended to completely replace SIL, to the point where I think it's effectively being abolished in England. But with just one exception, isn't there, Claire? I think where SIL will remain.
So mayoral SIL will remain in Greater London. So that's the exception.
All right. So the borough SILs will go in London, but the mayoral SIL is going to remain.
Yes.
Elsewhere, it will effectively be abolished. And in terms of the other aspect, then is this also the end for Section 106 and planning obligations?
We're told it's not, but that the role of Section 106 is really going to be scaled back quite significantly. And it appears that there's only going to be 2 situations in which Section 106 is now used. And the first one will be for site-specific infrastructure, where you're going to see narrowly targeted 106s, which cover infrastructure which is integral to the operation and physical design of a site. So we're talking about things here like internal play areas or flood risk mitigation. So that's one role for Section 106. And then 106s are also going to remain for delivery of the largest sites. We don't know what the largest site definition is going to be as of yet, but again, these are going to secure infrastructure which is going to be provided in kind. So the regulations, when they come forward, will define in detail how this process works. But we have been promised that the outcome of the regulations will be that the value of what's agreed under these 106s for the largest sites will be no less than what would be paid under the levy. Question how that's going to work in practice, how and who is going to determine equivalence between a 106 and the levy, but hopefully it's another point that will become clearer once we actually get to that consultation stage.
For those of us, which is probably me on this panel, but for those in the audience that are old enough to remember the introduction of SIL and the process that led up to that, particularly the debate around what was originally going to be planning gain supplement that was supposed to eradicate 106. One of the challenges that I think that process faced as it made its way through Parliament was the breaking of the link between development coming forward and the delivery of the infrastructure that's needed to offset the impacts of that development. And it feels as if that is a risk that needs to be addressed and needs to be thought about as this moves forward, because the more you devolve off the delivery of infrastructure to a levy, the more that you potentially leave development coming forward without the infrastructure in place to provide for it. So that role for 106, it was at the heart. Getting rid of 106 was at the heart of the introduction of planning gain supplement, which ultimately became SIL. And it feels like it's sort of here again, but they're still trying to wrestle with that, wanting to have things delivered on site versus wanting to have a sort of more standardized approach. And something that looks remarkably like a tax, even if we're still not calling it a tax. And that to me, I think it's interesting. The biggest developments are going to still be 106 rather than infrastructure levy, which that again seems to undermine potentially some of what they're trying to achieve with the levy. But who knows? Maybe it will all be resolved and all be clear and make perfect logical sense in the regulations, unlike the SIL regulations. We've had a question come in that looks at and is asking about the question of sort of how do you prioritise, and how is a planning authority going to prioritise spending of the levy? And the example that's given is if there's requirements under the habitats regulations for delivery of SANG and such like, does that get priority in terms of how a local authority prioritises the spending of the infrastructure levy? I suspect the answer is there's not a lot of indication yet as to quite how those things beyond this infrastructure delivery plan schedule that they're wanting planning authorities to draw up. I'm not sure it's clear yet. Is it fair?
No, that's how I'd answer the question. I think we still need to know how this is all going to work.
And there's a sort of supplementary come through from the same person asking whether it would be possible to effectively charge a tariff, a habitats reg type tariff, as you quite often see a sort of per roof contribution towards offsite mitigation of habitats reg sites. Is there an ability to do that alongside infrastructure levy? I think that it doesn't feel like that sits comfortably with the two areas where 106 is going to remain, and it feels as if you can't do it by 106, the answer is possibly no. Is it, Claire?
That feels to be right. Yeah.
Yeah. So I think subject to the detail in the regulations, it feels as if that's going to be something that's quite difficult to do. That sort of tariff-based approach to 106 that some would say is the answer to this issue. It worked quite well briefly before it was superseded by SIL. But I'm not going to be cynical, so let me move on. Although I'm not sure if I can even ask this question without sounding cynical. Around infrastructure levy, the explanatory notes talk about we're adopting something called a test and learn approach to infrastructure levy. That sounds like making it up as you go along, but tell me, Claire, it's not making it up as you go along. What does it mean?
I was going to say, I think test and learn does make it seem like there isn't a neat answer to a lot of the questions around the levy and how it's going to be introduced. So the plan, we are told, is that the levy is going to be rolled out over a period of several years. So allowing it to be introduced in certain areas and then for there to be monitoring and evaluation to see how it's working and to be able to tweak the system to make it as effective as possible. But what we're going to have in that time period is we'll have, I suppose, a patchwork across the country of areas which have the infrastructure levy, areas which are still operating by way of Section 106 and SIL. We all know how many times the SIL regulations have been amended. I think it's every year since they were introduced. So how long it will take to get to this effective system via the test and learn approach is anyone's guess, I think.
I'm not sure you're sounding any less cynical.
I was going to say, I'm trying to sound like, it will all be fine. It will all be fine.
It will all be fine, but if it's not fine, we'll test it, then we'll learn, and then we'll change it, and we'll keep going, and eventually we'll get to the right answer. Or in reality, by the time they get to something like the right answer, a new government will have come in and ripped up the rules and will have started again. We'll be testing and learning something else instead. Okay, let's move on from infrastructure levy. We're doing all right for time. We've got one last topic that I wanted to come to, and Tobias, I'm going to come to you if I may. Environmental outcome reports, again, has its own part in the draft legislation. I think this is intended to replace strategic environmental assessment and environmental impact assessment, isn't it?
Yes and no. So as people will be broadly aware, the current systems for environmental assessment, both of local plans and of individual projects, are broadly derived from EU directives. And whilst they've been sort of retained in UK law post-Brexit, I think there is a recognition that that isn't a sort of long-term sustainable approach. We do need to make sure that UK legislation remains up to date and takes account of sort of emerging information and scientific advances, for example. So the idea is that the new environmental outcomes provisions will replace, to some extent, the current SEA and EIA requirements. However, the bill does actually, in clause 127, make provision for the new requirements to interact with the existing legislative provisions. And once again, this is an instance where we'll have to wait to see the regulations in order to see exactly what level of interaction there will be. My understanding is that the idea is that it will be in effect a large-scale transitional provision, so that if you've already done an assessment or started an assessment under the current law, then you won't need to do everything again and start from scratch under the new system. But we'll have to see how they actually sort of work together in practice.
And looking at the again, the explanatory notes and some of the sort of publicity that the government has put out around the bill, their criticism of the current system appears to be that it's quite focused on procedure and process, rather than outcomes, and they're sort of suggesting that this will focus more on outcomes. Now, actually, I have some sympathy with them. EIA and SEA, we often advise clients it almost doesn't matter what the answer is, as long as you've got the process right and the answer is taken into account. It is a process based, and that sort of that legalistic rather approach is that it often leads to the challenge being less to the qualitative output of the EIA or the SEA and more to having missed a step in the procedure. So is it clear from the bill that they're moving in the direction of that focus on outcomes? Are they going to achieve that step?
I think that's the very sort of clear signal as that's what they want to achieve. And just in terms of sort of how the new system would work, in many respects, it would be very similar in practice to the current systems of environmental assessment. Where it would differ is that the government would have power to set regulations which prescribe specific substantive outcomes for environmental protection. And then, so as part of your assessment and reporting process, if you're a plan-making body or an applicant promoting a project. So as part of that process, you will also have to demonstrate that your plan or project will secure or advance the specified substantive outcome. Quite what those outcomes will be and how they'll be framed is a different matter, of course. The government is currently in the process of preparing for sort of fairly extensive consultation on those issues, and I think we'll get a much better flavour of what actually they have in mind on a practical level through that process. But unfortunately, the bill itself doesn't really give us much of a steer. What it does do is it does define what environmental protection, which is what the outcomes are supposed to achieve, relates to. And I think what's interesting is that it's very much predicated on the natural environment, cultural heritage, and the landscape. And that's sort of all very well. What's interesting is that compared to the current more process-driven approach, it's quite difficult to see how topics like traffic, noise, or socio-economic impacts are going to be assessed as part of this process. And as sort of our listeners will be aware, these are often some of the more contentious aspects when you're coming to promote a project. So it's quite difficult to see how that would actually fit into this more sort of substantive outcomes-based approach. To be somewhat glib about it, if you need to run 1,000 lorries to actually build the thing, then you need to run 1,000 lorries.
And I suppose and we've clearly established during the course of this session that I'm not cynical, but if one were cynical, then you'd be concerned that this might be an attempt to water down the environmental protections that we currently have. But actually, if that is the case, then there's a potential conflict with our international obligations, particularly thinking around the withdrawal treaty and the other treaties that were signed when we left the European Union, isn't there?
I think that's right, and it's a concern which the government is very clearly cognizant of, because clause 120 of the bill actually includes a provision which requires the Secretary of State, in making these environmental outcome regulations, to have a certificate on the regulations confirming that they don't regress from both the level of environmental law protection as at the date the bill is passed, but also that they comply with the UK's international obligations, not only in terms of the non-regression provisions in the EU-UK Trade and Cooperation Agreement, but also more broadly, and this is sometimes forgotten, but things like the Aarhus and Espoo conventions, which obviously continue to bind the UK regardless of whether we were EU members or not. So the government is aware of this. I think, being realistic, this is something which is highly likely to generate some fairly contentious litigation if the system is actually brought in.
And we've had, it's not really a question, but we've had a comment come through and come through from the audience, and I think it's a good observation. The person making the comment is suggesting that this is sort of, it feels as if it's in line with the Environment Act and biodiversity net gain that we were talking about recently, and that sort of looking at carbon reduction. It feels like there is a bit of a trend and a pattern there of this sort of focusing on the outcome, i.e. you will, BNG, for example, you will deliver a 10% net gain in biodiversity. Over to you to work out how to do it, but you will achieve that outcome. I think there is something in what the audience member's saying there, isn't there, Tobias?
Well, I think that is right, and I think it's interesting to see how this might actually interact with the Environment Act, which was passed last year, which obviously introduced a lot of the new biodiversity net gain requirements, because those specifically did not apply to, for example, the NSIP regime under the Planning Act 2008. And so it does seem as if this is the mechanism which the government is potentially going to try to use to actually introduce the equivalent requirements for that larger scale type of development, which the current EIA requirements apply to anyway. As I said, there's so much that we'll have to see what the detail of the regulations is. But for example, looking at some of the thresholds for Schedule 2 projects, and whether the government actually changes any of those to either increase or decrease the scope of what these environmental outcomes regulations actually apply to. In that regard, and to return to sort of your question, Trevor, about whether this allows scope to sort of water down environmental protection, something which I think is quite interesting in the bill is that the definition of a project, which would be something that the new requirements would relate to, is actually slightly broader than the definition of a project which is used for the current EU-based environmental impact assessment system. It, in theory, would cover not only physical interventions in the environment, but also changes of use without physical intervention. And so I think there is a very significant potential opportunity here that the UK could actually adopt a system of environmental protection, which is actually, first of all, more stringent than what we've had to date, and secondly, could actually be more effective at delivering the substantive environmental protection which the systems are supposed to deliver. So it's going to be an interesting next few months.
Thank you, and we've got a minute or two left, so it's probably just worth saying, Tobias, the everything we've been talking about up until environmental outcomes reports has been very much England focused, and to an extent this is still England focused, but there are some implications in terms of this part of the bill and the environmental outcomes reports. There are potential implications for the rest of the UK here, aren't there?
I think so, and I think that there are sort of, it works on two levels. First of all, the fact that England is doing it itself on a political level provides a steer as to what the potential future direction is for the devolved governments. And so obviously with the devolution settlement, it provides the flexibility to take a different approach. But I think certainly it will be interesting to see what the reaction of the UK devolved governments is to this and whether they propose something similar themselves. I think the second level that it operates on is the bill actually as drafted would give powers to UK ministers to actually prescribe these requirements in regulations for the whole of the UK. And my understanding is that this is already kicking up something of a stink, certainly up in Scotland, where there are fairly long established systems of devolved environmental protection already. So I think there's going to be potentially quite a rocky road ahead for some of these provisions.
Thank you, and we are just within our hour, so well done to everyone. We have had one last minute question come through, and I'm going to have a go at trying to answer it in a second. The question is whether infrastructure levy will impact on the ability to charge for BNG credits under the Environment Act biodiversity net gain system that we were just talking about. I think, as far as we can tell, but Claire, tell me if I'm wrong, I think the answer is no, the two systems are separate. So if you're buying credits to offset in terms of securing BNG. That's outside of the infrastructure levy. The planning authority won't need to fund the purchase of those credits through the levy it collects. Do you agree, Claire?
Yes, I think that must be right.
Splendid. Then bang on 11 o'clock. I would like to thank you all very much on the panel. Also thank our audience. We'll be back next month when we'll be talking about nutrient neutrality, the topic that's been exercising large swathes of the country over the last few months. So we'll be looking at some of the legal issues there. But in the meantime, thank you all very much and goodbye.